Hi, everyone. Carl Steinbeck here. Welcome. I thought I'd jump on tonight. And before I start talking about the Adelson case, I thought I'd talk about the new setup we have here. As you can see, this is an unfamiliar background, but Leslie and I have moved to San Antonio. So we were looking to go to Texas, and San Antonio is where we wound up. So we're in the middle of a construction zone kind of right here, right now. So I don't have the normal high-speed equipment from my brother John. That includes lighting and high-speed cameras and all that kind of stuff. So I'm just using my laptop here to do this live stream. But in any event, hopefully it works and we have good enough lighting. You guys can't believe how difficult lighting can be. I think there's like 9 or 11 lights we have on right now, trying to get this brighter. But in any event, this is the best spot we could do it from tonight. So in any event, the new studio should be done here in a few days. So you'll see more of a familiar backdrop there. But anyway, we just wanted to discuss tonight a few of the things that have been going on the last couple months, because just been working and trying to get settled here. So, but have been following the case. What's been going on. So I'm going to recap some of those things tonight, including the topic that I mentioned in the title, which covers the hearing that we saw Donna Adelson actually testify very briefly. And so I'll give you my analysis and comments and whatnot on that. And so first of all, I want to backtrack though, and one of the things I had not talked about is we saw that there was a release of the transcript of an in-camera hearing with a sealed hearing, and it looks like it was in judge's chambers with regard to the testimony of the eldest son of the Adelsons, being Harvey and Donna, who is a doctor, and the defense was trying to block him from testifying. And so we got to see a transcript. They had it posted for a number of days. It's not there anymore because it was in violation of a court order, and obviously Judge Everett was not happy about that being leaked. But it showed there's a discussion going on with the prosecuting defense. Sarah was the one talking for the prosecution, and the defense counsel for Donna at the time. It was very much an issue of. I thought it was really convoluted. It wasn't really clearly spelled out what Rob was there to testify for. It sounded like he was a witness that could do some damage against Donna, which I've said he's going to be a great witness if you just ask him, how did the family react after you learned of the murder of Professor Dan Markell? And their reactions would be speaking volumes as to consciousness of guilt. And so that's why I think no matter what he has to say about their reaction, it's going to do something along the lines of implicating them just by the virtue of the fact that they don't want to discuss, or the way they acted like they were not upset about it, things of that nature. So from my experience of trying many felony violent cases over the years, both as a prosecutor and defense counsel, that's the kind of thing I would be very, very honing in on and wanting to present that in front of a jury. So that kind of testimony is very damning when you think about it. Having your doctor's son testifying against the mother, it's not an easy thing to do, to testify against your mom, obviously, but when it's the right thing to do, and you're talking about murder, and this is he's also the uncle of the surviving sons of Professor Markell. So he's the kind of guy that we've seen as a person that has the highest impeccable integrity and standards of conduct. So somebody like him is not going to be condoning something like this. So if he's used, I think it would be a great thing, and I've encouraged the prosecution to do that from the live streams here. So in any case, it remains to be seen. He has been on the witness list on other trials, and he is going to be on Donna's trial as well. I'll get some of the scheduled deadlines here before we close out tonight. But I would expect him to testify, not just be on the list, but actually be called as a witness. So the other thing we had was a in-camera inspection for the judge to basically just be alone with the defense counsel investigator or investigators. I understand there's more than one, and that the previous defense counsel used for Donna Adelson, the ones that were conflicted and bounced out of the courtroom by Judge Everett, as he should have done, because that thing was a hot mess, totally drowning in conflicts, and should have never been there from day one. And finally things unraveled as was expected. but the thing is, it's something that's going to keep biting the prosecution's case. It's still going to be nipping at their heels because they still have this issue that's swirling around. This just the defense investigator that the judge previously said, if you heard that hearing and remember, he said that after the defense counsel, new defense counsel, Zellman and Fulford said like, well, were we allowed to talk to the defense investigators that the previous counsel hired? And the judge said that basically that was not a wise move because that's sort of like fruit of the poisonous tree. And so that's why they're thinking, well, we got to find out what this guy had to offer. So now they're going to have the judge interview this investigator, see if it's conflict free, to be able to reduce that down to, I guess, a transcript that they can view and stuff like that. But this thing is still, from my experience dealing with conflicts and my states and my 4 states I'm licensed in, I would not. You don't want to go anywhere near a conflict. You don't want to have something presented in front of a judge. You don't have a right. You're not going to be able to interview the witness the way you want to, that you're going to rely on the judge interview him. He doesn't know what angle of attacks to pursue and that kind of stuff. So it's just one of these things that it's you're trying to do damage control as a judge, as a prosecutor, because you don't want the whole case turning upside down on appeal and the conviction being reversed because of this conflict issue. But it's a conflict issue that's sort of lingering, always out there. And how you handle it is sort of like a hot potato. And because it's so rare to have something this much of a direct constitutional conflict crisis, it's really sort of like you're treading on new ground here, so to speak, to blaze a trail and try to figure out as you go, because it just really reeks of double dealing of which client was represented more zealously. Right. So if you have 2 clients, one of them is you're trying to represent zealously to the best of your ability, and the other one has a conflict with that one, it automatically is going to put you in a situation where which client are you more loyal to? And that's what the courts are going to decide. And so we also heard this issue on YouTube. I guess Leslie was telling me about it. There's some folks that are saying that this was the appeal was denied for Charlie on his request for relinquishment of jurisdiction back to the trial court. And so that was something that is not something that is a big deal, because they just denied a motion. This is not an appellate brief that they filed. In fact, that's another bizarre thing. It's like, where is Charlie's appellate brief? There's no appellate brief filed. They've already missed the deadline. And there was this motion to relinquish jurisdiction. Does that extend the deadline to file a motion for appeal? Apparently it does. I've not found anything in the Florida appellate procedure rules that allows this to happen. So I guess I'm sure Ufferman, the appellate attorney for Charlie, knows what he's doing on that regard and not letting something expire. But this is really bizarre how can this thing extend that long when there's actually a deadline that's been blown without an appellate brief being filed. And as we can expect, one of the things that the appellate brief will include, and the main thing that I suspect will happen, is the ineffective assistance of counsel by Daniel Rashbaum, who for many years was representing Donna before he took on Charlie's case. And based on the fact this is a family conducted murder of the Florida Adelsons, automatically there's different degrees of culpability, different interests that they have, and how to best come out unscathed if you're defense counsel representing them. So automatically, when you go from Donna to Charlie, that's a huge red flag. And accordingly, Rashbaum got bounced from Donna's case, and now the issue on appeal is going to be like, should he have been even representing Charlie at his trial where he got convicted? And was he more loyal to Donna and interested in protecting her rights to be avoid a prosecution by having her not testify? When you stop to think about it, Charlie had no alibi, no corroboration to support his theory that there was this what he calls extortion plot, which I call a robbery on a payment installment plan because it's so far-fetched and absolutely ridiculous of a defense story. So in any event, as I'm looking at this thing with the conflicts coming out, I still think, I hope I'm wrong, but it's like if you got to rip the Band-Aid off at some point, because Charlie was denied a constitutional conflict-free counsel. I'd rather have that be resolved earlier than several years down the road. And we may not know right away exactly how it turns out in the next year, even, or 2 years, because it could go up to the Florida Supreme Court. And even then, if they rule in favor of the state and say, no, the conflict wasn't prejudicial to the extent that his constitutional rights were deprived, there still could be a collateral attack in federal court where they bring up that ineffective assistance due to conflict. So this could be many years a festering issue that is not really resolved. And so it's such a oddball thing to do as a lawyer. From my experience, that it's just sort of one of those things. Like I say, it's going to keep lingering around. The new counsel are going to be wondering, what do they do? Where do they go? Who can they talk to? Can they ask what the previous? If they talk to a witness that's already been interviewed by the defense, do they, can they ask them, what did the defense ask you before? What did you say before? I mean, even that's like sort of bizarre. And also, I thought it was odd that the defense counsel said they spoke with prior counsel without getting additional conflict type information. But that's something I can tell you that I would never do. If I was taking on a case and there was a previous counsel that was bounced by the judge for being conflicted, I would not talk to them at all. I wouldn't want their discovery file. I'd want a clean discovery file from the prosecution. And I would assume if the guy was conflicted, I wouldn't want to know anything that they did, because nothing I would trust is usable. I would start fresh and start anew. So I think that that was a sort of an odd thing to see for me. But in any event, we have we had the motion to perpetuate testimony. That's a recent thing here this week, that this past week, that Donna even testified, which is something that she just testifying in a motions hearing like that, I thought also was a strange thing. So the sum and substance of this issue was that Donna had heard from a couple witnesses that were drug addicts, homeless, and completely unreliable, in and out of jail, lengthy criminal records apparently. And one of them apparently was already out of jail, but the other one wasn't. So they were going to be out released on like the 1st of February. And so it was an emergency expedited motion request by her defense counsel to have the judge order a deposition before these witnesses were too strung out on drugs, unavailable. They couldn't find them. Maybe they're living in some, some box on the side of underneath a bridge or something. So these people are like really like the least credible people you'd want to testify in your case. And yet that's what Donna was asking for. So they actually had Donna called as a witness, sworn in, and had Donna describing what she had heard from these two witnesses about how Katie McBanois was describing how she was going to get off scot-free in the end, that she was going to be in Hawaii and things of that nature, to because she also said things like she was going to burn the Adelsons, set them up, and that she also had blackmailed Charlie with that extortion racket thing. So it looks like they really do want to use this extortion racket defense. And so I thought that was another confirmation of just how weak her defense is. A defense would really want to use these kind of people that are that incredible. And I can tell you, as a defense lawyer, you don't put your client on the stand for anything. From my experience, I would not do that, because what that does is you just don't want your client saying the wrong thing, and there's always that risk. So, and it sounds like from the end of the hearing that Donna wasn't even prepared to testify. So that was really high risk maneuver. And you notice they really led when Fulford, the attorney, female attorney for Donna, when she was asking her questions, she basically just was trying to extract a yes or no response from Donna, and she was being completely leading. And finally, at one point, Donna was cut off because Georgia said objection leading, and then Fulford had to rephrase it. And then that's when Donna started talking more in a narrative format instead of just answering yes, no. But even with that narrative format, Donna, when she was saying how basically something needs to be done because these, people are going to be unavailable, or one of them already is, and so the judge told her to stop it, to stop talking. So if you recall, that second time, Judge Everett has told her to stop talking. So that's probably also going to happen at the trial, where she's going to go off and keep talking when there's objections, and the judge will have to admonish her for not following. court procedure. So yeah, I see some of your comments saying that she's desperate. Yeah, it's really desperate, and I think it's also a sign. I look at everything, and what I try to convey on this channel is I try to look at everything through the eyes of what the defense counsel are thinking, what the prosecutor is thinking, and I can anticipate the defense counsel letting her testify. It shows that they're just trying to have goodwill with their client, and they're letting her get up there and rant about this being an important evidence, that kind of thing. Because if it was really that important, what you can do is make what they call a proffer, where you're just basically giving a summary to the court. Well, this is what this witness, and I'm not going to restate their names, but these two female witnesses that Donna wants to use for her trial, and therefore get these quick depositions knocked out. They could have just given a summary to the judge, which is sort of what they did, but they wanted to, I guess, preserve the record better. So then they called Donna to describe what she heard from these two witnesses. But what's interesting is that they didn't even try to call any of these two witnesses, which if they would have done that, they probably could have gotten that testimony in trial that way. So instead of using Donna to testify what she heard, which would not be admissible in court, most likely because of hearsay rules, that they could have just called the one that was already in jail and had her describe what she heard from Katie. So, I mean, who knows if any of this is true, what these people are saying. Maybe Donna, coached these folks to say something. Maybe she gave some assurances on the outside when they got out. But they also have a pending change of venue request by the defense. And that change of venue request would actually really work against having these two these drug addicts from finding out how to get to the courthouse. That could be 100 or 200, 300 miles away from Tallahassee. So that would also work against them. And but anyway, it just looks really to me like defense counsel are they're just desperate at this point. They've seen the writing on the wall. This thing's a slam dunk win for the prosecution, and they got to resort to more shenanigans of a circus type behavior for witnesses. And what's Donna going to have for corroboration of any of her main material points that she's going to try to make when she testifies at trial? She's not going to have them. And so I think that all this is a really good sign for the Markel family. I think that this is a sign that she's also wanting to take control and take charge of the case. And she doesn't trust her lawyer. She wants to get up there and testify. And like I say, when I see lawyers calling their client as a witness, it usually indicates they're trying to let the client feel like they have some control over their case when they really don't. They even asked Donna, do you want these folks to be called as witness? It's not up in the American justice system. It's not up to the client on who's called as a witness. That's a lawyer's decision. The client may want somebody to testify or want a certain lineup of witnesses, but who's to call as a witness, what to ask them and stuff like that, that's ultimately the attorney's call. It's not the client's call, not even in a murder case. Someone's facing a murder trial. It's ultimately up to the defense counsel to decide who is called as a witness and what is asked. And so it just looks like they're trying to appease Donna. And so they probably are not telling Donna what a loser of a case it is. And so Donna's getting probably really mentally beat down being in that Leon County jail for this many months, and she's still got to wait until June before she goes to trial. So it's obviously noticeable she's not doing as well as when she first got there and showed up in Tallahassee when she was arrested in Miami. So with her age and the kind of food and whatnot, I understand she's going to art classes, maybe some physical activity, but it's not a whole lot because people that are in jail are normally in and out of there within days or weeks. They normally are not there for months or over a year like she is. So, and at her age, it's got to be really dragging you down and wearing you out. So I will say that the other thing is the appeal. Let's go back to the appeal. The appeal for Charlie, that is something that when we do finally get a verdict from that, a court of appeals opinion on that, I should say, that's going to be, when you stop thinking about it, that's going to be another probably year and a half down the road. Even if they filed it tomorrow, it's going to be a time that's probably going to be up to a year and a half before the courts decide. So Charlie's up in South Dakota prison, just wondering what the heck has taken so long. Why hasn't anything been filed? And he's still banking on the fact that this conflicted counsel that he has is going to be able to set him free. But in the end, he's just going to be retried if it becomes a issue that's reverses his conviction. And the prosecution will have it that much easier when they actually go to trial the second time around. Well, like I say, I hope I'm wrong, but I'm just telling you from my experience, it's just unsettling to see that kind of conflict. And we do have normally a better justice system than that, from what I've seen in America, where we don't have somebody that's that conflicted be representing somebody at of all cases, a murder trial. So with that, we have, let me go over some of the quick timelines of the judge schedule. Judge Everett says February 11th is going to be the case management conference. That's not going to be having a whole lot of substance to it at that point. Judge may ask if there's any plea negotiations in the works, that kind of thing. Just trying to get idea if his docket is going to be cleared up in the future. But that he did have a discovery deadline of the 30th of April. Pretrial motions also the 30th of April. Witness lists are also due the 30th of April. And then on the pretrial hearings for the motions that are raised on the 30th, they're going to have a 16 May pretrial hearing. And then the actual jury trial will start on 3 June. And they anticipate the jury selection be over by the 6th. And the actual first witness will testify after opening statements on the 9th of June. So, and I expect it's going to be probably at least a 9-day trial as well, like Charlie's was, maybe another day or two longer. But in this particular case, it's so much a mirror of what happened in Charlie's case. The whole time I was watching Charlie's trial, I was thinking like, gosh, more Adelsons need to be at that counsel table. This is really, really, really hard on the witnesses, and especially the Markells having to suffer through this, and because they're obviously not living in the Tallahassee area, they have long travels to make and that kind of thing. So Donna should have been convicted right alongside Charlie, and actually would have probably prevented Rashom from trying to double dip and represent them both at the same time. And so, in any case, that's what I have for my opening analysis tonight. So I'll go ahead and jump to questions. If you all have questions, go ahead and put a triple Q with the emoji red question mark before and even after if you can. It helps distinguish questions from comments, and I'll do my best to answer questions. If I don't have anything turned on in terms of the super chats, whatnot. So those of you, if you're watching this after the live stream's over, if you don't have premium, YouTube premium, then you got to obviously suffer through those ads, which are not deletable from my end. And so just go ahead, save your money, and instead of super chat, which is not an option, I turn that off. Go ahead and just get premium if you haven't. And the other thing is, I know some people asked me, I think one of the last live streams, they asked, should I turn on closed caption? And the closed caption is actually done on your end. So if you see that little gear in the as the option below the screen, I believe it is, for YouTube, if you go to that gear, that gives you the option of a number of different things, like to play back a little bit faster or slower, as well as to have the closed caption. So you do that at your end. And so I think that's about it for now. Let me go ahead and jump to the questions. All right, and you're asking, will Harvey attend the trial? I think Harvey has to attend the trial unless he's on the witness list, and he won't be allowed in the there to watch what's going on. Now, prosecution can make an exception if it's a family member like that, to allow Harvey to be there, even though he's going to be testifying. But I just don't, since they've never called Harvey as a witness before, I don't think he's being called. So I do expect him to be there behind Donna. He stopped to think about it when John and I were there at Tallahassee. We didn't see anybody look like they were there to support Charlie. I mean, he came from Miami up to Tallahassee, and there's not a single person that consoled him and said, "Oh man, I'm sorry you got convicted." Nothing. It was all like everybody acted in the courtroom was like, "Hey, this is just expected." It just was a rite of passage. You got to call his witnesses, do the arguments, but it's like a slam dunk win. So. Okay, postpartum for days. You're saying, does the defendant have a say on if they appear for these hearings in person versus Zoom, or is that decided by the judge? A lot of that can be arranged between what the defense counsel are asking for and what the judge allows. So I would say there's no set thing. It all depends on how important it is to have the defendant there. Uh, Normally, of course, years ago, you would never have a Zoom option. Everything always had to be where the defendant was there in person. If there was going to be a hearing, pre-trial hearing, they were always there. So nowadays, things are more lax, and you can have the defendant observe and or testify or both via Zoom, and that's they have statutes. All states have statutes that afford that option. So it's not. No, I would say it's not the defendant's call at all. It's more or less the defense counsel that has to make that request. Edward, you made a comment here. You agree that the Adelson's minus Rob should have been convicted by now. It's been 10 years plus. We're just getting it down. Yeah, it's really a shock. Kevin Hornbuckle, you're asking, will the Florida appellate courts have to wait for the bar investigation of Rashomон's ethics contortions? That is something that's the appeals court is not needing to find out. If they do want to, though, they could hold up the appeal while that's pending. And so that's it's not controlling, but it could be something that's it's also outside the record, so they would probably know about it. Could maybe affect them, but it doesn't really have to affect their judgment at all if they know the facts on how Charlie had this conflicted lawyer, and that's why I thought it'd be a good thing to go ahead and grant the motion to relinquish jurisdiction back to trial court to really find out and put Rashomon on the stand and ask him some. If I was a judge, I'd want to like basically wire brush him and wring his neck, trying to find out what the heck were you doing. So you were representing Donna for years before you got on this case, and just get into the details of some of that without violating the things of the attorney-client privilege. It's just general parameter facts on dates of representation and things of that nature. And so yeah, it's not going to hold it up, and but definitely could have an impact on it at some point. To Colorado. Also, Tiffany Nicole, you're saying, do I think Donna's realizing she's cooked? I think from the sound of her voice, I think she realizes she's really nervous. I mean, you've been sitting there over a year now, and you're dealing with all new attorneys and somebody that you considered your son, Rashbam, basically up and left you, resigned, and just threw in the towel and said, well, basically, there's a conflict. And that's the thing. Conflicts, most people don't really understand how they operate, and not even many lawyers that are civil lawyers, but criminal law lawyers, they're the ones that understand it the most because we have it so much happen where it's not waivable. I know many conflicts in the civil world for civil attorneys it's waivable, not in criminal law arena. That's something you don't really want to waive, because there's always that constitutional issue in effect when you don't have a constitutional issue when it's involving civil law matters. Dreamscape, you're saying Rashomon has gone very quiet. When do you think we'll hear from him again? Also, will he admit insufficient assistance at Charlie's appeal? He's going to maybe be asked to give a statement, but I think it's going to be self-serving. He's going to try to say how it wasn't a conflict, but there's just no way. I think he's going to be able to tap dance around that thing and make it look like he was able to zealously represent both parties when he already was ruled ineffective by Judge Everett. So Judge Everett's ruling, from what I would expect for Florida, if it's like any of the other states, you basically would have the judges finding that he was engaged in a ethical conflict. It's probably more controlling on the bar committee than vice versa. So I think the judge making that declaration is going to make some kind of disciplinary action happen to Rashomon, but whether it's heavy or light, that remains to be seen. Thanks, Alicia. Yeah, San Antonio is beautiful, isn't it? Julie Nielsen, you're asking why did a local lawyer say the trial go 3, 4 weeks? Well, you know what? You have different lawyers that maybe don't know so much about the case. And, I was on, what was it? I think it was on Court TV one time. There's another lawyer from Dallas that was saying that that Wendy Adelson was very credible. She came across very credible in her police interview and stuff like that. So I mean, people say stuff and are not adequately prepped, and so that's it's one of the reasons I was able to get talked into this by my brother John. So yeah, it's not going to go 3 to 4 weeks. That's ridiculous. So. E. Hill, are you saying Donna first heard about this months ago, but it's only come out now? Craziness. Well, I think depending on what if she didn't tell her lawyers right away or whatnot, or maybe her lawyers looking at the case and going, God, um, these are really like what you'd call dirtbag witnesses to have to help bolster your defense, and we're really scraping the bottom of the barrel if we have to use people like that. So, if you got to use people like that, gosh, if Donna wants them, I guess why don't we go ahead and try to call them and do this motion. But yeah, I mean if that's what you're relying on to try to have impeachment evidence against Katie McBanwell, good luck. It's not going to happen. Okay, Alex Perkins, you're asking if anyone thinks Rashomon intentionally stuffed up both Donna and Charlie on purpose to try to for mistrial. I don't think he intentionally did this. I think the he just lost his way and didn't really focus on what the ethical standards are because he had so much money being able to be made by representing two Adelsons. So that's all I think it is. Okay, Barbara, you said you heard Donna and Harvey having nonstop phone calls every day. Yeah, I mean that's something that is allowed when you're in jail to have phone calls, and I guess you can pay for them there. So, but you know what? She's not having a lot of visitors, and I haven't checked lately, but I'm sure that she's never had her daughter Wendy visit her. And with that being the case, I think the boys, their grandsons, in her visit her as well. So she's basically been cut out of her entire family tree except for her husband. So Wendy's not seeing her. The grandsons aren't seeing her. Harvey may put them on the phone if they're visiting there, but Wendy's now up in Austin, Texas, with the boys. So how they're not going to be talking to their grandma Donna, and then you also got obviously the oldest son. He's not talking to him, and so yeah, Donna did that to herself. Isn't that something? What a tragedy of life to go after someone with murder to try to take away your grandson's father just for the sake of you being selfish and wanting to have more time with him in Miami. Move to Tallahassee. Wouldn't that have been easier? What a tragedy. This is like the most bizarre crime you could possibly find, I think, when you look at all the different shenanigans going on, all the different lawyers that have messed up, and it's just like it's like if you had this on a movie case, nobody believed this was like possible in real life, really. So, okay, Teal, you're asking what's the mindset of the attorney who has to retry a case? Would Georgia feel more confident a second time or frustrated still continuing? Well, on one hand, I think as a prosecutor, you'd be going, gosh, when are we going to get these, be done with these prosecutions? But then in the end, it's actually your boss and or you being the one that's not charging more Adelsons. And so the mindset of an attorney has to retry a case. I think you're talking about a prosecutor. As a prosecutor, if you have to retry a case, in this case, Donna's not being retried because she never had her trial, the first one. It was supposed to start the day of that Rashbaum withdrew, but trying to a case from that never got off the ground with Donna and an original trial date, and now she has new attorneys. So I would say that the retrial that we had was with Meg Banoff, for example. So that always helps the prosecution. The prosecution does get better the second go around. They can interview jurors and find out what they should have done better or different, and that really normally helps the prosecution. So I would say that's maybe frustrating that they basically are realizing now that, yeah, we should have tried Donna, at least Donna, with Charlie as well, but they blew that chance, and now they got to go through all this extra work. And I don't think they would have had that conflict issue. Like I say, I don't think Rashbaum would have tried to put his head around representing both Donna and Harvey in the same trial or right around the same time, doing back-to-back trials within months of each other, if they did have a severed trial for the two of them. So okay, I think Jamie Polizzi, you're asking, what's your opinion on the Farabo testifying? Which parts of his testimony are admissible? I think things that he observed about his mom. I think if he's just going out there to say what she was a terrible mom or something like that, or she's very controlling. I think it has to be more tied into to her character that's related to maybe the hatred of Dan. That would be very, very damaging to have him talk about how she could not stand Dan. Also, how she hated on his now current wife that he basically caused the breakup of years earlier before things were rekindled. So the amount of control that Donna exerts on other people, especially family members, is incredible, and I think that would be definitely relevant. But as I said, the transcript is sort of like meandering and sort of like mindless chatter. It's sort of Rashbaum just sort of making some pompous remarks and trying to be flamboyant in front of the judge, which is not appropriate if you're in closed chambers hearing like that. So in any event, I think that we'll see some good things coming out of the son Rob at Donna's trial. Julie Nielsen, you're asking, when is the ruling on the change of venue request? Don't know a timeline. The judge is not having to put that out there anytime in the next coming days. It could be a few more weeks, I imagine, or it could even be another month or so. I do not expect that motion to be granted. It's very hard to get a motion for change of venue. And there's not enough people in Tallahassee that even understand and follow this case and the murder of Professor Markell. So, okay. And Nancy, you're asking, will I be attending the trial in June? Still don't know. Leslie and I have talked about it. And, the thing is, it's like, gosh, there's parts of that trial I'd like to attend, but being gone for that many days, seeing the whole thing, maybe we'll swoop in for the closing arguments and see the jury verdict. But really, it's just so disappointing to, not have her be tried with Charlie and then going through logistics of getting to Tallahassee and all that kind of stuff. It just sort of makes it discouraging to go there. But I do plan on at least covering the trial on the live stream here. I think I backed up on some of the questions instead of going forward, so I apologize for that. I'm not sure what happened to my mouse. Charlie's airline miles going to waste. Okay, GG Bruja, you're asking, would it have been better for the defense to stay quiet on these two women, develop their stories, then call them in rebuttal at trial? Well, I think if you do have a concern that some witnesses will be unavailable, it doesn't meet the rule. The rule requires them that they pretty much are expected to be or will be unavailable for trial, and that gives rise to a deposition. And the prosecution, if they wanted to do a deposition, Georgia was saying she needed more than 2 days prep to be able to do a deposition if this one's getting out of jail right away. But if it's helpful to the defense, I'd just be like, okay, let's do a deposition. We don't need to have a hearing on this. That's just sort of my my motif as a prosecutor, because I figure, you know what, if I got a guilty party, let them try whatever they want, because I'm just going to crush them in court. It doesn't matter if they bring up these homeless addicts and need their videotape testimony, because you don't know where they're at by the time the trial starts. You know, I'll be in there and cross-examine them and totally destroy them if they don't have any credible testimony. So I wouldn't be worried about that. But a lot of prosecutors, they try to stop that kind of stuff, make it more difficult for defense. That's just their prerogative. I mean, they are following the rules, but I think on stuff like this, I would just be, hey, you want to call a witness or whatever? Yeah, go ahead. I'm not worried about it. In the end, I think whenever I prosecute somebody, I want to make sure the defendant walks out of the courtroom feeling like they got a fair trial, and that I wasn't just some kind of a obstructionist and basically blocking critical, vital, exculpatory type information. So, but yeah, I think they probably won't be available for trial from the sounds of it. But it sounds like Georgia's going to go ahead and interview them and try to get some kind of a testimony about it. But maybe the thing is also, as a defense attorney, what I'd be worried about if I throw these witnesses out there and I haven't even talked to myself, and it's only been like they had an investigator talk to at least one of them. I'd be worried about the fact that, what if my client put these people up to that and promised them certain things, or gave them certain things, especially money, to make up some stories, and they were coached on what to say. So that could always come back to really burn you in a trial. And then the whole case is pretty much really gone on. And then if they have some kind of evidence that Donna was basically soliciting folks to make up stories for her to help with a sham defense. Okay, YouTuber 2003, you're asking what happens next trial. Lost track for a while. And basically, it's Donna's trial. Donna was supposed to have a trial last fall, but it got derailed the first day of expected testimony and opening statements, because Rashom had to recuse himself because Offerman, Charlie's appellate lawyer, said he wasn't cooperating, and Charlie was listed as a witness for the state. He's most likely going to be called in rebuttal by the prosecution, or to rebut anything Donna said that wasn't consistent with what Charlie said about the details of this bogus robbery on an extortion payment plan type of thing that was laughable. Okay, Dreamscape, you're saying Garcia was apparently moved last month, and your opinion is this relevant to the case against Donna? I'm not tracking that there's any movement there, but I don't think that's going to be relevant to the case at all. Movement of inmates and whatnot is pretty common, so I don't see that being an issue. Yeah, Alex Perkins, a great point. To me, you're saying the most tragic part is Dan was an amazing, all caps, father. The Adelsons don't have true love. If they did, they couldn't have murdered the kid's loving father. Boggles the mind. Yeah, that's, the thing that's even still boggling the mind is how these boys are having limited visits with the Markells. And so it's a real tragedy. They're still suffering. And, it's basically the extermination of the entire family tree is what Wendy's been able to accomplish. So it's really disgusting. These children deserve better. They're an ongoing victim every day. And even to what extent they get minimal visitation, it's definitely never enough to make up for the horrific loss. Andrew Diamond, you're asking if Donna and Charlie are allowed to talk. Well, Charlie's in prison, so and Donna's in jail. So there would be because they are both in facilities like that. I would say that they're not allowed to do that. Do I know for sure? No, but I would say that would be highly unlikely. Two co-defendants, one of them that's been convicted, the other one's pending trial, would be allowed to talk. Okay, Bugs Bunny Brunner, you're asking, can Harvey be charged with fleeing prosecution aside from murder? I think that would be better as an instruction if he's also charged, which I've been advocating. He should be also charged, just like Charlie and Donna. And but that's conscience of guilt if you're trying to escape the country and whatnot. So that's very damning against him. And as I've done a video another time, there's ample evidence to get him charged and prosecuted as well for his involvement in this. YB, you're asking, do I have a podcast? The jail could access your podcast one time. I don't know what you mean by podcast. I guess some people call this a podcast, but I don't know. It's not like some of these other things that I can't even think of the names of them off the top of my head. But this is no, this is the only thing here on YouTube. I do have an X channel that I haven't posted anything lately on that, and also have TikTok, which I haven't posted much on that either. But anyway, I'll probably get more into those here as we get settled. Junebug, you're saying, do we all know if there's any jail calls to or from Donna to and or from Rob? I've not heard of that. I think Rob's never talked to his mom the whole time she's been in jail. So there was a falling out after the murder happened, shortly after the murder. So I do not see him talking to her anytime. I think the first time they'll have any face-to-face is if he's called as a witness. Yeah, Dixie Doodles. I wish the state would have more confidence in their case against one of the YouTube jury overwhelmingly would vote guilty. Yeah, that's absolutely the case, and it's just a real head scratcher. P Dog, you're asking, do you think Wendy is getting tired of looking over her shoulder? I don't know. I think that I think she's probably thinking that she's unscathed, no matter how close the rounds get to her. I think she's able to psych herself out that way. So I think she's able to, just like she doesn't have the conscience about the kids seeing the other Markel family on a regular basis, an extensive basis, and just letting them have them for a couple of weeks over the summer. Everything is micromanaged and controlled tightly, as if they're afraid the boys might get the truth exposed to them. So I think in that sense, she sees that working out as well, and she's obviously conscious that really looks bad in court because visitation normally increases a micro millimeter every time there's going to be a court hearing coming up, and then she'll spin it and lie about it. So yeah, they need to get moving out on this thing. Let's see here. Purple Diva. Sorry, you're saying the worst case scenario. What can prolong the trial? Well, I mean, any number of things can prolong a trial. You could have a lawyer get sick, get in a car accident, a material witness is unavailable that the prosecution or defense need, and they ask for continuation. So, yeah, it's short of something emergency like that happening. I mean, I would really. I'm really trusting this trial to proceed on schedule. So back pain forever. You're saying what's the point of the hearing? Can't they just call them as witnesses? Well, that was the point. These are like people that are living out of cars or under bridges and stuff like that, and addicts. And when they're in the prison, when they're in Leon County Jail, then obviously they get a chance to sober up a little bit if they've been there for more than 30 days, especially. And so that's what they're trying to do, is have them available when they're not high to testify. Bugs Bunny, it's Brian. You're asking, in rewatching the trials, why do two of the judges take no juror questions while the first judge always took questions? I don't know what you mean by taking questions. Ultimately, it's up to the attorneys to ask the questions. There's some judges do the initial streamline in the beginning. They do the prep work for the jury selection. I think that's what you're referring to. So each judge does it differently. That's up to their prerogative on how they want to conduct the jury selection. And so that's what you're saying there. This judge's individual preferences are coming to light there. Yeah, this is relying on a homeless crack addict, or yes, cracks you up, I should say. So yeah, it just shows you that the prosecution underestimated how strong their evidence is. Harmony Riki, you're saying, do I think the state or the defense will call Charlie to testify? I think it's going to be the state, and because Charlie's such damaged goods on the witness stand. I mean, he's gonna sink Donna for sure if he's brought to testify. So it doesn't matter what he says. The jury isn't gonna like him. They're gonna see him for what he is, a convicted murderer, and they're gonna. It's that much easier to make the connection with Donna being part of this as well. Yes, I don't want to even try to say that. So Donna's going to try the double extortion defense. Yeah, that's what it's looking like. I mean, if she tried to have a new defense different from Charlie's pretty much her only comfort factor there. I think that's what they're going to do, but that's that much easier for the prosecution to poke holes through that. Like I've said, I don't think I've ever heard of a more preposterous defense story. It was so elaborate in so many details. He had the perfect excuse for everything. It's just you just don't find that in real life, where the guy's able to, you know, dodge that many bullets on stuff and just be able to say, "Oh, that was all harmless, innocent behavior," and I was extorted and blackmailed, and yeah, I wouldn't call the police. I wouldn't talk to an attorney. I just did nothing except talk to my mom for 2 years about it, and Katie, and so yeah, it's just ridiculous. Okay, Kevin Hornbuckles. He's a prosecutor here. He's saying I'm prosecuting a crime in the state court in Oregon. I just discovered new evidence which is incontrovertibly proves the state attorney knowingly presented a sham defense. Bar complaint is filed. So yeah, that's I mean, you can have, I guess you're saying the prosecutor presented a sham defense. I guess you're saying sham evidence, maybe not defense. But in any case, you can see prosecutors going to real bizarre, extreme lengths to try to get somebody convicted. I mean, if the evidence is there, you don't need to bolster it. If the evidence is there to prosecute and get a conviction, then my whole mindset is if the guy is guilty, I'll be able to get a conviction, and I'll be able to prove it. And anything they throw against the wall, I can just rip it apart because I've done my homework better than my opposing counsel. So I go in there with that kind of confidence and expectation and knowledge that I'm going to win the case, and it makes it like sort of shooting fish in a barrel. So why a prosecutor do that kind of thing? Bring forward some kind of bogus evidence that they knew was fraudulent to try to get a conviction. Yeah, that's really scary, isn't it? It's one of the reasons why people say, "Well, how can you ever do defense work?" Well, you're just sort of like making sure the justice system works in an honest fashion. Okay, so you're saying I don't have a podcast. Okay, I think that's sort of I forget the names of those things. The apps that have that. All right, let's see here. Hey, you know what? Thanks for also, you guys are awesome for being clean and respectable on this channel and having an intelligent discussion on stuff. So I've not had to had anybody here screened and bounced or put in timeout for being inappropriate. So thanks for your professionalism. I respect and appreciate that. Uh, Bling Chick, you're saying, does prolonging the trial benefit the prosecution or the defense? Normally, the defense has benefited from prosecution delays. The there's a saying, justice delayed is justice denied, and that means it's for the defendant more than is the victims. But the thing is, witnesses can become unavailable, and certain times things can develop and improve it. Like if there's a better enhanced evidence that comes out for DNA, for example, that crimes can be solved that way. So normally it helps the defense, but in some ways it can help the prosecution. But the real disturbing thing is if you got murderers walking the streets free and clear, and they can murder again or feel like they can still be corrupting the folks around them and society as a whole. So I think that it's very much something that a prosecutor needs to zealously go after the guilty and not allow things to be delayed for ridiculous, slow reasons that just really make you scratch your head and go, "What the heck is going on?" So. Okay, here, deer in the headlights. You're saying, I bet Wendy's so glad she changed her boy's last name, Adelson. That's a winning name, right? Well, I think that why wouldn't you change the name back to Markel, right? Why wouldn't you do that? And so anyway, it's just really bizarre. And if you stop to think about it, now would be the perfect time. They moved and left all their friends in Florida here in the last months. Why wouldn't they start out fresh and come up with a new last name, their original last name, I should say, of Markel, as the honorable tribute, right thing to do, that was stolen from them. Their namesake, the Markel namesake, was stolen from the boys in a very cruel, vicious fashion. Okay, it's 8:02, so I'm going to go for a few more minutes here. And Lisa Burton, you're asking, can the boys legally change their name back to Markel? Well, they're still minors, so they're too young to do that. But maybe they'll do that when they turn 18 or shortly thereafter. That would be a really cool thing to see. Stacy's mom, you're asking, how desperate is Donna to come up with such a ludicrous story about two addicts who just happen to have info from Katie? I've dealt with these kind of jailhouse snitches before as a prosecutor and defense counsel, and it's just usually never something that really helps the defendant that much. So usually you see them helping the prosecution, and I would say that the prosecution, the kind of like weighty material stuff that they can bring in and help prosecution, is normally not that significant. Normally some kind of confession or something of the defendant that you see in these kind of situations. So here for the defense to say that you got a material witness that's saying things that are impeachment type of evidence, I think that's it is pretty weak. I mean, I wouldn't want to use that kind of testimony in trial if it's something that's that weak and pathetic. I mean, think about it. You're going to talk about how this evidence came to light. You heard about this evidence, and it's people in jail. The jurors are going to know that Donna's been in jail. They're going to figure Donna had a chance to corrupt these witnesses to say something in her favor. So normally you try to not let the jury know that the defendant's in jail, but I think here, I mean, I think it's going to come out. And my theory is that jurors do look at the internet and do Google searches. They're going to search Donna and Charlie and Harvey and Wendy and all that kind of stuff, and really do do a deep dive, trying to find out what's really going on behind the scenes other than what they see in court. So even though they're sworn not to, I think that's what I've seen in my experience. So I think that's going to be the same thing here. So that's not going to bode well for Donna either. So, and well, it remains to be seen if these two addicts are able to present themselves in court. And like I say, why didn't they just call one or both of them at the hearing, and they could have preserved the testimony for trial that way? And so I think they didn't really think they were that credible. Otherwise, they would have done that. That's my theory anyway. Alex Perkins, you're saying I couldn't even follow the double extortion. Seriously, how stupid did Dan and Charlie think everyone is? Astonishing. Well, if that's what your client comes up with, you just throw it against the wall, let it see where it sticks, and it's so laughable. That's why I thought when Rashomon was doing his opening statement, he was dragging it out for so long. I mean, he didn't even talk about what Charlie's defense was until like 40 some minutes into his opening. And that's why the longer that they kept you hanging there wondering what is your defense going to be, the more I knew that that's a stall tactic, and he was just basically just trying to drag it out. And I mean, I'm surprised he's able to say that story with a straight face. So that could also have been why he's dragging out, because it's certainly going to make you start busting up laughing. I know I'd have a hard time laughing, expecting anybody to believe that that kind of story. Jim, I agree. Regardless of who this defendant, the government choice to be held to its burden of proof. Yes, no matter how guilty they may otherwise be seen. Yeah, definitely they're presumed innocent, and the government has to prove it beyond a reasonable doubt, and they should be confident they can prove it beyond a reasonable doubt, and act accordingly and be aggressive and tenacious, and let defense hire tenacious lawyers too, and try to get an acquittal or a hung jury. But it's not going to happen in Donna Adelson's case. Oh, thanks, Kevin. You're saying when you go to court, you're buoyed by my model of analysis and competence. You're a pro se plaintiff. I mean, being pro se is very hard to do. There's a lot of rules, and if you're going against another attorney, that cannot be a fair advantage. It's an unfair advantage for the other side. But I think the thing I always look for is I want to know the truth of what I'm doing. As the truth is on my side, I'm like, I'm not worried about the outcome, because I'm going to be able to show the truth, and the other side, they're going to have to basically manufacture lies, and if you've been doing this a while, it's pretty easy to expose lies, and you can even just go in there without much preparation. If you know enough from your client telling you the truth, you can go in there and just mow them down. But yeah, I would say preparation is a key. I would say that's the reason why I've won so many cases, is because whether I'm prosecution or defense, the opposing side just doesn't do their homework, and they don't really know the truth, and so anyway, that's the key: doing your hard work before trial, and then knowing the rules of court and the evidence beforehand. And like I say, if you got truth on your side, I mean that should carry the day, but you got to have your skill set in place. Okay, G Road, are there any calls between Harvey and Donna? Yeah, there would be, and they're being recorded, but they're just not releasing those kind of things. So they want some kind of privacy for Donna, I guess, before trial. And they want people like us talking about it on podcasts and YouTube channels. Mr. Monks, understood you asked if I follow a Karen retrial at all. Yes, I've done that. And just one day I covered it, and that's all I did. I was predicting the outcome that pretty much was the next day we found out how the jury voted. So that pretty much was just a prediction I had, just having limited knowledge of the case. But yeah, that's I don't know if I'll go back to that one. People are so rabid about that one. It's really bizarre. Okay, I think I'm going to shut it down here. So you all have a great night. Thanks for following the Just for Markel efforts. And I don't know if I'll be back on for the case management hearing on the February 11th, but I will be covering this case still. That's the intent anyway. So thanks for your support for Just Markel's. We do know that the Markels follow this channel at different times. So we know that they must appreciate your support as well. And we will not let this this crime go unpunished. We will adequately encourage the prosecution to do the right thing and ramp up their efforts to prosecute the remaining guilty parties for this horrendous murder. So with that, I'm signing off. Have a great week and take care. Be safe.